Good morning. I hereby call to order this 11th meeting of the Pennsylvania Public Utility Commission for the year 2018. And what we will do differently today is something that is very important to us here on the bench as commissioners, but also commission staff. We want to take the moment to acknowledge the passing of two of our former commissioners, former chairman here at the commission. That is former Chairman Robert Bloom, who was the longest serving member of the Pennsylvania Public Utility Commission, serving in his first term from the year 1971 to 1979, and then returning in 1995 and serving until 2005. We also want to acknowledge the passing of former Vice Chairman Tyrone Christie, who was appointed under Governor Rendell in the year 2007, serving into the year 2011. These two are stalwart commissioners that served here at the commission with much passion and commitment to the work that we do here today. So we just want to take a moment of silence to acknowledge their passing. Please stand. Thank you. At this time, we will remain standing for our Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. And as always, we want to give you the reminder of our safety message that is on the front or on the inside cover of our first page of our agenda. So moving on to matters of this morning's agenda, we want to do the approval of the minutes for June 14, 2018, and I will recognize Commissioner Kennard, who is the editor.
Thank you, Madam Chairman. I've reviewed the minutes of the June 14th, 2018 public meeting and recommend that they be approved as submitted.
You have heard the motion of Commissioner Kennard for the approval of the minutes. Is there a second?
Second.
Second by Commissioner Sweet. Any discussion? Any further edits? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Moving now on to our agenda, we will call up our Secretary, Rosemary Chiavetta, who will lead us through today's agenda.
Good morning, Madam Chairman. Good morning, Commissioners.
Good morning.
Your various offices and bureaus present the following agenda for your consideration, beginning on page 1. It is recommended by Director Monahan and the staff of the Bureau of Audits that the Commission adopt the release of the audit report of PPL Electric Utilities.
Is there a motion to adopt the staff recommendation?
So moved. Second.
Well, third.
I keep going.
One at a time.
Okay. We'll go by seniority. The motion was Vice Chairman Place, and the second was by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 2 and matters presented by Acting Director Marinko and the staff of the Office of Special Assistance. It is recommended the Commission adopt in an omnibus motion all of the items on page 2 and both of the items on page 3, ending with the tariff supplement filed by the Reynolds Water Company.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 4, it is recommended that the Commission adopt the proposed opinion and order in the matter of Senator Andrew Dinniman versus the Sunoco Pipeline LP.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion?
Madam Chairman, Commissioner Coleman and I have a motion to make. Before the commission, we ask that the motion be entered into the record as if I had read it in its entirety. Before the commission are the compliance filings submitted by Sunoco in response to our June 15th, 2018 stay. These filings were made in compliance with the two directives imposed upon Sunoco by the Commission as a condition to removing the injunction regarding construction on ME2 and ME2X pipelines in West Whiteland Township. Our motion would partially lift that stay. Sunoco has satisfied the first directive of the two directives that we imposed by our June 15th order. These made with respect to the inspection, testing protocols, comprehensive emergency response plans, and safety training curriculums. The second directive required by Sunoco was to obtain permits from the Department of Environmental Protection to resume construction. In its compliance filing, Sunoco identifies 8 segments of ME2 and ME2X where Sunoco has obtained the appropriate permissions from DEP to recommence construction. Sunoco also acknowledges that there are 4 remaining locations for which they have yet to receive the requisite permits from DEP. With respect to those 8 locations where permits have been received, Sunoco has complied with that second directive. Accordingly, we believe our injunction regarding construction on ME2 and ME2X should be lifted at those 8 locations. With respect to the 4 locations where Sunoco has not yet received DEP permits to continue construction activity, the injunction remains in effect. Accordingly, Sunoco is directed to file supplemental verifications or affidavits upon DEP's issuance of the remaining permits so that this commission may review the outstanding injunctions. Therefore, remove 1, that in our previous injunction is discontinued with respect to the 8 locations on ME2 and ME2X pipelines in West Whiteland Township for which Sunoco has received permits from DEP to continue construction activities. 2, that our previous injunction remains in effect with respect to the 4 locations on ME2 and ME2X in West Whiteland where permits have not been received from DEP. Thirdly, that Sunoco shall file supplemental verifications or affidavits that DEP has issued the appropriate permission in West Whiteland Township when granted by DEP. Number 4, that the Office of Special Assistance prepare an opinion and order consistent with this motion. Thank you.
Thank you. You have heard the joint motion of Commissioner Kennard and Commissioner Coleman. Is there a second?
Second.
Second by Commissioner Sweet. Any discussion on the joint motion?
I guess I have a statement on the matter.
Vice Chairman Place.
Thank you. Madam Secretary, I ask that my statement be placed into the records if I read it in its entirety. As noted before us today for the consideration disposition are filings, compliance filings submitted by Sunoco in accordance with the Commission's June 2018 order. The Commission's June 2018 order maintained the interim emergency order imposed by the Minister of Law Judge on construction of Mariner East 2 and 2X in West Whiteland Township until such time as Sunoco filed certain documents with the Commission. Specifically, Sunoco was directed to file a verification or affidavit that the Department of Environmental Protection has issued the appropriate permission for continued construction of ME2 and ME2X in West Whiteland Township when it is granted. Sunoco submitted affidavits on July 3rd and 18th, 2018 for Commission review. It is clear from the Commission's June 2018 order that the proceeding before us is the continuation of issues of substantial public interest and public safety concerns of a project of the magnitude and complexity of Mariner East natural gas liquids pipeline project including in West Whiteland Township. As noted in both the Commission's May 3rd, 2018 order as well as in the June 2018 order, the area of West Whiteland Township in Chester County has experienced events which have raised serious questions regarding the safety of both ME1 and continued construction of ME2X and ME2. The Commission has further recognized that construction of ME2 and ME2X has posed more serious challenges, including the effect of certain drilling on local residential and commercial wells on the citizens of West Whiteland Township. The Commission's June 2018 order also found that although Sunoco testified that it is not continuing with construction until the new DEP permits are issued in West Whiteland Township, it is prudent that the new permits be in place prior to restarting work on ME2 and 2X. Further, the Commission found that it is undisputed that Sunoco intends to proceed with the work of constructing ME2 and 2X upon receipt of the appropriate authorizations from DEP owing to the notice of violations and possible amendment and or modifications of its permits. Given the overarching public safety concerns articulated in the Commission's June 2018 order regarding the construction of ME2 and 2X, I believe that it is prudent to maintain the current interim emergency order and join the construction of ME2 and 2X in West Whiteland Township, as Sunoco has not met the requirements as set forth in the Commission's previous order. In its July 3rd and 2018 submittal, Sunoco indicated that they have not yet received all necessary DEP permits required for continued construction in West Whiteland Township, including that the company is yet to apply for some of the required permits. Sunoco's actions are contrary to the Commission's directives, which I believe are clear regarding the need for the receipt of all necessary permits to ensure safe resumption of construction of ME2 and 2X in compliance with the concerns expressed previously. Further, I find that the company's submissions are inadequate to assist the Commission in its further analysis of the safety concerns regarding construction of ME2 and 2X in West Whiteland Township. The information submitted regarding their existing DEP permitting authority does not include adequate permit details such as issuance date, type of permit, copies of the existing permits, or additional information to verify their adequacy. Sunoco's submissions simply list in a chart that DEP approvals have been obtained for 8 locations in West Whiteland Township, including a map and support. I believe that this minimal information does not comply with the Commission's directive at ordering paragraph 7 of the Commission's order. In addition, Sunoco only provided a status of construction in the permitting process for 4 other locations in West Whiteland Township. In the status report, Sunoco does not explain when or how we will complete certain requirements, such as a satisfactory reevaluation report of the Devon Drive, Shone Road, Biddle Drive location, or its ongoing site activities at the Exton Bypass Lisa Drive location. In addition, Sunoco does not provide sufficient information regarding its pending major modifications of existing Chapters 102 and 105 permits at North Pittsfield Pike and Swedesford Road, including the adequate permit modification details such as filing date, type of modification, existing permits, or additional information, including how long the matter has been pending or an anticipated approval date. Sunoco's submissions are scarce in necessary details and hamper the Commission's ability to review their permits and pending modification to determine if they have complied with the June 2018 order and can resume construction safely in West Whiteland Township. The public safety issues alleged in this proceeding do not call for the submission of minimal information. Rather, the Commission directed that comprehensive permit information is needed so that we can ensure that continued safe operation of ME1 and the safe construction of ME2 and 2X in West Whiteland Township. Because Sunoco has failed to furnish all necessary DEP permits and related information regarding its construction in West Whiteland Township, I believe that Sunoco has not complied with the Commission's June 2018 order. Also, because of the lack of specificity in Sunoco's submittals, which are counter to the clear and comprehensive requirements of the Commission's 2018 order, I dissent in this matter. Thank you.
Thank you, Vice Chairman Place. I also have comments to be submitted on the record. I ask that they be submitted in their entirety. In ordering paragraph number 6 of our order entered on June 15, 2018, maintaining the injunction on construction of Mariner East 2 and Mariner East 2X in West Whiteland Township, we directed that Sunoco provide to the Commission certain inspection and testing protocols and a comprehensive emergency response plan. In both instances, we stated that the response should include, but was not limited to, certain items, for example, leak detection and repairs, and public education materials and notification protocols in the event of a pipeline-related incident. While Sunoco's June 22nd filing complies with the Commission's order, I note that Sunoco opted not to provide 1 iota more than was requested and did not, in my opinion, attempt to assuage the concerns regarding lack of transparency voiced by the parties in this proceeding. That being said, Sunoco's June 22nd filing comports with the directives in ordering paragraph number 6. In our June 15th order, we also issued the following directive to Sunoco: that Sunoco Pipeline LP shall file a verification or affidavit that the Department of Environmental Protection has issued the appropriate permission for continued construction of Mariner East 2 and Mariner East 2X in West Whiteland Township when it is granted. On July 3rd, 2018 and July 18th, 2018, Sunoco made responsive filings regarding the Department of Environmental Protection permits. Sunoco's filings show that the DEP has issued 8 of the 12 required permits. Sunoco requests permission to restart construction in the 8 areas where the DEP has issued permits. Because Sunoco has not fully complied with our order regarding the DEP permits, I do not agree that the injunction on construction should be lifted. Ordering paragraph number 7 speaks of West Whiteland Township as a whole because it was not our intent to allow the resumption of construction in a piecemeal fashion. The clear intent of ordering paragraph number 7 was to verify to this commission that all DEP work stoppage directives to Sunoco in West Whiteland Township was lifted and that the company had expressed authority to resume or begin construction of Mariner East 2 and 2X. So therefore, I respectfully dissent on this motion. Any further discussion?
Madam Chair,
Commissioner Sweet.
I now feel compelled to make
Feel compelled.
2 brief comments.
Here you go.
I was 1/3 of the majority that voted in favor of the June 15th, 2018 order. And I can say that I had no such understanding of the intent of the motion at that time as has been just expressed. Construction activities require permits. Permits are granted in an iterative, perhaps piecemeal basis. They are not granted or applied for or granted all at once. The reference to West Whiteland Township meant exactly what that says, that the permits were located, the necessary permits were located in that particular township. Paragraph 7 is only about 15 words, and I can only read those words as well as reflect my own intent. In reading those words, the commission explicitly said that Sunoco needed, quote, permission, unquote, in order to proceed with construction activities. I believe that the granting of a permit, in this instance 8 permits, is permission to undertake those specific discrete activities for which a permit application was submitted. Therefore, because of that small bit of reasoning and trying to call the pitch as it's thrown across the plate, I intend to vote in favor of the motion. Thank you.
Thank you, Commissioner Sweet. Any further discussion? Hearing none. On the joint motion, all those in favor say aye.
Aye.
Any opposed?
Opposed?
And I also will be voting in the negative. The vote on the joint motion is 3-2, noting the dissent of Vice Chairman Place and myself. On the matter as amended, are we okay with taking the previous roll call? On the matter as amended, the final vote is 3-2, noting the dissent of Vice Chairman Place and myself.
Turning to page 5 and matters presented by Director Diskin and the staff of the Bureau of Technical Utility Services, it is recommended that the Commission adopt the proposed opinion and order regarding the petition of UGI Utilities for an extension of their long-term infrastructure improvement plans.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Sweet. Any discussion? I do have a statement for the record. Before the Commission for consideration are the petitions of the 3 UGI gas utilities for extension of their existing LTIP, or long-term infrastructure improvement plans. The companies propose a 1-year extension to allow time for the Commission to consider their pending merger application. I note that UGI PNG and UGI CPG previously obtained approval to waive their disc cap from 5% to 7.5% until the company's next LTIP filings. I dissented in both proceedings. That the record did not include any facts dealing or detailing any approval of a waiver would facilitate any material benefits for the company's at-risk pipeline replacement. I wish to highlight the fact that the commission approval of the instant proceeding will correspondingly lengthen the disc cap waiver period set by the commission. This extension will therefore have implications on the rates for UGI CPG, and understanding that the UBI PNG has received approval of new base rates since implementing its disc waiver. Nonetheless, today's proceeding is not a proper forum to rehash my concerns with the disc waiver. Today, the question is whether or not these one-year extensions are warranted. Upon review of the record, I find the fact that these extensions would provide for administrative efficiencies depending on the outcome of the UGI company's pending merger acquisition persuasive. Therefore, I support the LTIP extensions proposed by the UGI companies. Any further comments or discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Continuing on page 5, it is recommended in an omnibus motion that the commission adopt the remaining 3 items on page 5, all of the items on page 6, with the exception of the 3rd item, PPL's petition for waiver and letter of notification, which has been postponed to the public meeting of August 23rd. Continuing with the omnibus motion to include all of the items on page 7, and the first 3 items on page 8, ending with the security certificate filed by the Pennsylvania American Water Company.
Is there a motion to adopt the staff recommendations?
So moved.
Second. Motion by Commissioner Sweet, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And the final item on page 8, it is recommended that the commission make public the quarterly earnings report of Pennsylvania Utilities.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? I don't see anyone's hand up, so I don't, no discussion.
I understand that Commissioner Coleman has a statement.
I'll defer to the Vice Chairman.
Vice Chairman Place.
All right. Madam Secretary, I ask that my statement be placed into the records if I read it in its entirety. Before us for disposition is the report by the Bureau of Technical Utility Services regarding the quarterly earnings of Pennsylvania's investor-owned public utilities for the quarter ending March 31st, 2018. The Tufts report adopts a proxy return on common equity capital of 9.65% for investor-owned electric public utilities, 9.95% for natural gas public utilities, and a proxy ROE of 9.85% for the investor-owned water public utilities. The adopted consensus report represents a 0.44% figure above the discounted cash flow calculated result of 9.21% for the electric utility company Barometer Group, a 0.3% figure above the 9.65 DCF result for the natural gas distribution utility company Barometer Group, and a 1.8% figure above the 9.67% DCF calculated result for the water utility Barometer Group. The same staff calculations under the capital asset pricing model indicate ROE results of 9.01% for the electric utility company Barometer Group, 9.61% for the natural gas distribution company utility Barometer Group, and 9.93% for the water utility company Barometer Group. Thus, the adopted consensus ROE figures for the electric utilities and natural gas distribution utilities are also higher than their representative CAPM calculated estimates. The calculated DCF results of 9.21% for Pennsylvania's electric utilities is higher than the average authorized ROE figure of 9.1% for the 3 investor-owned electric utilities that operate in the PJM region and neighboring states under conditions of electric choice and competition. Relevant ROEs were authorized in base rate cases in the first half of 2018. In comparison, the consensus ROE figures of 9.65% for Pennsylvania's electric utilities also manages to exceed even the average ROE of 9.63% that has been authorized for 4 integrated electric utility distribution systems in the same region during the first half of 2018. Lastly, the consensus ROE figure also exceeds the average national electric utility ROE authorized in general rate cases of 9.58% in the first half of 2018. Similarly, the consensus proxy 9.95% ROE figure for Pennsylvania's natural gas distribution utilities substantially exceeds the 9.33% average of the ROEs authorized for natural gas utilities in the same region and exceeds the national average of 9.55% for the ROEs approved in general rate cases during the first half of 2018. Thus, any arguments that lower proxy ROEs in Pennsylvania will cause capital migration to other states lacks quantitative factual support. The adoption of these proxy ROE revenue figures and rate effects, I'll start that again. The adoption of three of these proxy ROE figures has revenue and rate effects for the prospective distribution system improvement charge mechanisms in various utilities. Furthermore, the Commission's establishment of these proxy ROE figures can and does have implications for pending base rate cases where these numbers can be used as generic guidance. I have both substantive and procedural concerns in the proxy ROE results adopted here and the process that is used to produce them. ROE figures that the Commission adopts on a quarterly basis must be consistent with the applicable legal standards of the U.S. Supreme Court in its Bluefield and Hope decisions, as well as applicable Pennsylvania law. ROEs must not only satisfy shareholder expectations and attract capital, but they must also meet the just and reasonable standard for the resulting rates that a public utility charges its customers. The analytical techniques and models that the staff utilizes are based on market-driven data and provide quantified measures and calculations of ROE set points. Thus, these DCF and CAPM-based calculations are characterized by certain levels of consistency, practicality, and empirical rigor. The same cannot be said of the various consensus ROE increments that are added onto these calculated ROE estimates. Awarding an ROE that exceeds the utility's market-driven and estimated cost of common equity capital induces economic inefficiency and the concomitant losses of consumer welfare. It is also debatable whether ROEs that exceed the market-driven and estimated cost of common equity levels provide any additional incentives for accelerated infrastructure investment and improvements, especially in light of utility-proposed and commission-approved long-term infrastructure improvement plans and associated DISC mechanisms. Furthermore, if this is the goal of the additive ROE increments that are applied to the conventionally calculated ROE estimates, the Commission is required to make explicit findings to that effect and ensure that the resulting incentive ROE levels are required and utilized for the intended purpose. Additive increments on top of the conventionally calculated generic ROE figures that are utilized for DISC and potentially other purposes are fundamentally unnecessary in view of Pennsylvania's favorable regulatory environment. The DISC mechanism itself and the availability of a fully projected future test year in base rate cases provides substantive opportunities for Pennsylvania public utilities to earn authorized rates of return and corresponding ROEs. I also believe that the process for the adoption of the quarterly proxy ROEs for the Pennsylvania investor-owned electric, natural gas, and water utilities requires quantified rigor, a better degree of transparency, and findings that are compatible with a standard of just and reasonable rates. The commonly accepted theory, practice, and methods for deriving the cost of common equity capital and authorized ROEs for regulated public utilities may permit the use of additive increments in recognition of specific and mostly unique risks. However, assuming that such risks are present and have not already been captured through the conventional use of the DCF and CAPM methods, their explicit recognition and quantification for each specific public utility industry group is clearly lacking when the quarterly consensus proxy ROE estimates are adopted by this Commission. The process for adopting and publicizing the quarterly proxy ROE figures needs to change. The TUS report should contain specific staff recommendations on the proxy ROEs to be adopted for the electric, natural gas, and water, wastewater public utility industry groups. To the extent that increments need to be added to the calculated ROE figures, the addition of such increments must clearly reflect enunciated risks that are specific to each of the public utility industry groups. The relevant analyses must be contained in a formal Commission order that modifies the staff recommendation in a transparent manner and in accordance with well-established and followed Commission practices and procedures. For the foregoing reasons, I do not support the proxy consensus ROEs of 9.665% for electric utilities, 9.95% for natural gas utilities, and 9.85% for the water utilities. Thank you.
Thank you, Vice Chairman Place. Any further discussion?
Chairman, I do have a statement that I'd ask to be entered into the record as though I read it in its entirety. At the risk of prolonging this discussion, I think there are a couple of points that are noteworthy this morning. In considering the quarterly earnings report, it's important to realize that the DISC return on equity the Commission sets every quarter also serves as the over-earning threshold. To say that there should be no basis point adjustment to the market-based discounted cash flow, or DCF, analysis is to say that any company that manages to reach the average rate of return must be punished by reaching the DISC to, or returning the DISC to zero. If the Commission were to design rates around a market average return on equity, the regulated utility achieved that return to the penny, they would be deemed over-earning, which seems unreasonable to me. While I understand that there are some concerns on the basic point adjustment to the discounted cash flow may appear to be somewhat opaque, this has been the design of the DISC from day one, which is inherent in rate design since before most, if not all of us in this room, were even born. In fact, in 1944, the Hope case, which the Vice Chairman cites, explicitly held that, quote, "The result reached, not the method employed, is the key consideration in setting the return on equity." Pennsylvania was the first state to implement DISC, and the DISC has long been recognized by our National Association as a best practice. It has been mentioned time and time again by financial analysts, including Fitch, Standard & Poor's, and Moody's, as a strong positive factor to regulate utilities' credit rating, which directly results in cheaper debt for them and consequently more money in the pocket of ratepayers. It is my belief that the position taken by the majority today conforms with the Commission's policy and precedent and will ensure that Pennsylvania continues to show the benefits that the DISC can achieve for both utilities and ratepayers, which includes clean drinking water, safe delivery of natural gas, and the reliable provisions of electric service. The wisdom of our approach is evidenced by the accelerated replacement of infrastructure since the DISC implementation and the associated economic benefits realized in the Commonwealth of Pennsylvania. While you've made an excellent start, there are many years of work remaining. I hope that the Commission does not depart from the model that has been proven to be efficient, effective, and transparent means of supporting the rollout and maintenance of critical public infrastructure throughout Pennsylvania. Thank you, Chairman.
Thank you, Commissioner Coleman. Any further discussion? If not, I do have some comments for the record on this issue. Today, the Commission releases the quarterly earnings report for the 12-month period ending March 31st, 2018. In this report, the Commission officially publishes the single return on equity, or ROE, as you have heard, figures for each fixed utility industry to use for their respective distribution system improvement charges, and as the over-earning cap to protect customers from unreasonably excessive or excess distribution rates. It emphasizes the point that those ROE figures have this dual purpose because it is formative to our deliberations and considerations when ultimately setting these figures. In these dockets, the Commission utilizes market analyses to come to an informed decision on ROE figures, which appropriately balance the dual purpose of the number. In other words, there is not a specific formula by which the Commission must commit to setting the ROE figures. The figures set at this docket, in my opinion, are reflective of market circumstances and appropriately reflect the consideration of their dual purpose, and therefore I support the release of the report. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed?
Opposed?
The motion passes 4-1, noting the dissent of Vice Chairman Place.
Turning to page 9 and matters presented by Chief Counsel Panque and the staff of the Law Bureau. It is recommended in an omnibus motion that the Commission adopt both items on page 9 regarding the implementation of Act 40.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Kennard. Any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 10 and matters presented by Chief ALJ Rainey and the staff of the Office of Administrative Law Judge. It is recommended that the commission adopt ALJ Buckley's initial decision in the case of Craig Jackson versus Metropolitan Edison Company.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Sweet. Under discussion, I do have a motion, so I'm going to turn it over to Vice Chairman Place to preside.
Thank you. I would like to recognize Chairman Brown for the purposes of a motion. Chairman Brown.
Thank you. I ask that my motion be spread upon the record in its entirety. On August 28, 2016, Craig Jackson filed a formal complaint alleging that MedEd had not adhered to a consistent policy for cutting trees, harassed him due to his race, failed to restore his property following vegetation management, and requesting that MedEd be prohibited from spraying chemicals on the property. MedEd's response denied the allegations. On February 9, 2017, the ALJ issued a second pre-hearing order stating that the commission does not have jurisdiction or authority to resolve allegations of harassment due to race or to make any determination save whether the utility has violated specific provisions of the code or the rules and regulations of the commission. The second pre-hearing order also directed the complainant to amend and augment his original complaint to state with specificity which of his properties were affected by MedEd's alleged conduct and to further explain his complaint. The complainant did not file an amended complaint as directed. However, at the pre-hearing conference, he clarified which property was involved. As it turns out, it was the property listed on his complaint form. On May 5, 2017, MedEd filed a motion to dismiss due to complainant's refusal to respond to its numerous discovery requests. The complainant did not file a response. By initial decision issued April 11, 2018, the ALJ granted MedEd's motion to dismiss the complaint with prejudice. I believe that the second pre-hearing order issued on February 9, 2017, which stated that the commission does not have the jurisdiction or authority to resolve allegations of harassment due to race or to make any determination save whether the utility has violated specific provisions of the code or the rules and regulations of the commission, was overbroad and erroneous. The commission has wide authority and jurisdiction under Section 1501 of the code to determine whether utility service is reasonable. This includes the manner in which a public utility renders customer service. Additionally, Section 1502 of the code prohibits public utilities from subjecting any person to any unreasonable prejudice or disadvantage. The ALJ misstated the law when he determined that the commission was without authority to rule on an allegation that a customer was mistreated by utility personnel. Because the second pre-hearing order, which framed the scope of the hearing, was erroneous, the matter should be remanded for hearing consistent with this motion. I note that the initial decision stated that it took direct questioning from the ALJ to get the complainant to answer basic questions about this case. This is not uncommon with pro se litigants. Now that the complainant has affirmed that the property at issue is the property listed on his complaint and has answered the question of which exhibits he plans to utilize at hearing, MedEd is in a position to defend claims levied against it at hearing. Therefore, I move that 1, the ALJ's initial decision be reversed consistent with this motion. 2, the complaint be remanded to the Office of Administrative Law Judge for an evidentiary hearing. And 3, the Office of Special Assistance draft an opinion order consistent with this motion.
Thank you. Having heard the motion, is there a second?
Second.
Seconded by Commissioner Sweet. Under any discussion of the motion? I have a statement in the matter. Madam Secretary, I ask that my statement be placed in the record as if I had read it in its entirety. The complainant filed a formal complaint alleging the MedEd did not provide reasonable service in a dispute concerning vegetation management on the complainant's property, as noted. In this complaint, Mr. Jackson raised numerous vegetation management issues, but also alleged that the company resorted to harassment and racial profiling for cutting the trees. I support the remand in this case as Mr. Jackson clearly raises numerous issues that are within the Commission's jurisdiction. Of particular note is the Commission's jurisdiction to adjudicate complaints where racial or other unreasonable discrimination has been alleged in the provision of utility service or as to utility rates. The Commission's authority is clearly stated in Section 1502 of Title 66, which specifically prohibits unreasonable discrimination in the provision of public utility service to any person, corporation, or municipal corporation. In addition, longstanding legal precedent dictates that the Commission has exclusive jurisdiction to adjudicate allegations that a public utility company has discriminated in rates and/or services for whatever reason. Further, the Commission's regulations specifically prohibit discriminatory practices in certain industries, including taxicab and generation supply services. This Commission's fundamental obligation is to ensure that we fulfill our statutory requirements and enforce our regulatory mandates on the utilities within our jurisdiction, guaranteeing that the provision of service and the rates charged to customers are not discriminatory or prejudicial in any manner has been settled for many decades and is absolute. Thank you. Any further comments? Seeing none, all those in favor signify by saying aye.
Aye.
Any opposed? Motion carries 5-0. Chairman, the gavel is yours.
On the matter as amended, is there any objection to taking the previous roll call? Seeing none, the matter as amended passes 5-0.
It is recommended that the Commission adopt ALJ Johnson's recommended decision in the case of Mahoning Township versus Buffalo and Pittsburgh Railroad.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 11, it is recommended that the Commission adopt ALJ Gould's initial decision in the case of Kelvin Thomas versus the Philadelphia Gas Works.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Vice Chairman Place. Any discussion?
I have a motion, Madam Chair.
Commissioner Sweet.
Thank you. I ask that my motion be placed on the record as if I had read it in its entirety. Before us is the initial decision of Administrative Law Judge Marta Gould in two cases brought by Kelvin E. Thomas against Philadelphia Gas Works, PGW. One is a timely appeal of a BCS informal decision, which was appealed by PGW, and the other was filed as a formal complaint several months later by Mr. Thomas. The two cases were consolidated. A timely appeal from an informal determination of BCS is de novo, meaning that no part of the decision or proceeding before BCS can be relied upon in the formal proceeding. Regardless of who brings the appeal, the burden of proof in a formal complaint in a timely appeal from BCS remains with the party that filed the original complaint. Should Mr. Thomas decide not to participate in the formal complaint proceeding, both complaints should be dismissed for failure to prosecute and the BCS determination should be vacated. A complication in this instance is the uncertainty surrounding the service of process upon Mr. Thomas, as evidenced by multiple returned documents. To ensure the due process has been provided, the case should be remanded to the Office of Administrative Law Judge. Therefore, I move, first, that the case of Thomas v. PGW and Kelvin, the two cases, at dockets F-2017-261-1788 and docket 2017-262-1275 are remanded to the Office of Administrative Law Judge for additional proceedings consistent with this motion. Secondly, that the initial decision of Administrative Law Judge Marta Gould is vacated. And third, the Office of Special Assistants prepare an appropriate order consistent with this motion. Thank you.
You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Commissioner Kennard. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended, if there's no objection, we'll take the previous roll call. Seeing no objection, the matter as amended passes 5-0.
Continuing on page 11, it is recommended that the commission adopt ALJ Gould's recommended decision approving the joint petition for settlement of the Philadelphia Gas Works.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second?
Motion by Commissioner Sweet, second by Commissioner Coleman, who was louder than Commissioner Kennard. Sorry about that. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And the final item on page 11, it is recommended that the commission adopt Special Agent Arnold's initial decision dismissing the complaint of Amber Cozart versus the Philadelphia Gas Works.
Is there a motion to call the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Is there any discussion?
So I have a motion on the matter.
Vice Chairman Place.
Thank you. Madam Secretary, I ask that my motion be placed in the record as if I had read it in its entirety. Before the Commission today is the initial decision of Special Agent Alfonso Arnold III dismissing a request for a second commission-based payment arrangement. The record indicates that Ms. Cozart requested a payment arrangement after she had declined to join PGW's Customer Responsibility Program and defaulted on a commission-based payment arrangement, her first. The special agent's recommendation is to dismiss the complaint requesting a second payment arrangement in the absence of a change in income under sections 1403 and 1405D of the Public Utility Code. Though the record correctly reflects that Ms. Cozart has not had a change in income, a customer may qualify for an extension of a payment arrangement under Chapter 66, 1405D if there is a significant change in circumstance. This definition includes, among others, catastrophic damage to a customer's residence resulting in a significant net loss to the household. In her request, Ms. Cozart indicated that her household suffered a bedbug infestation which resulted in damage to her home and its contents. As the record stands currently, there is not enough information to determine whether the resulting damage was catastrophic and if this is a qualifying event for a payment arrangement extension. Additionally, I question whether PGW's CRP calculation for Ms. Cozart is in compliance with its Commission-approved Universal Service and Energy Conservation Plan. The record indicates that under PGW's CRP, Ms. Cozart would be required to pay $107 a month. She declined participation in this program as this amount was only $2 per month, less than the $109 per month commission-based payment arrangement which she was granted in 2017, which she deemed unaffordable and subsequently upon which she defaulted. This $107 a month CRP calculation represents more than 27% of Ms. Cozart's $402 monthly income for a household of four and leads me to question how this amount was calculated and whether the calculation is accurate. Ms. Cozart's income is 19.2% of the applicable federal poverty income guidelines, and according to PGW's Commission-approved USECP for 2017 through 2018, households enrolled in CRP that are below 50% of federal poverty income guidelines are to be charged 8% of income plus an additional $5 a month toward arrearage forgiveness if applicable. For Ms. Cozart, this would amount to approximately $32 in addition to a $5 arrearage charge for a total of $37 per month, $70 less than the $107 CRP amount included in the record. As issues of fact remain in this proceeding, I move to remand this case to the Office of Administrative Law Judge for further proceedings as necessary to develop the record regarding the extent and impact of the household's bedbug infestation, to determine how PGW calculates household income, and whether Ms. Cozart's CRP payments amount is consistent with the approved USEP and other rules and precedent as applicable. I have a keen interest in consumer cases and universal service programs and look forward to reviewing this case when it is concluded and subject to further commission review. Therefore, I move that 1, this matter be remanded to the Office of Administrative Law Judge to further develop the record in this proceeding as to the issues set forth in this motion. 2, the Office of Special Assistants prepare an opinion and order consistent with this motion. And 3, the initial decision issued by Special Agent Alfonso Arnold be vacated. Thank you.
You have heard the motion of Vice Chairman Place. Is there a second?
Second.
Second by Commissioner Sweet. Any discussion on the motion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0. on the matter as amended? If there's no objection, we'll take the previous roll call. Seeing no objection, the matter as amended passes 5-0.
Madam Chairman, that concludes the regular agenda. Now turning to the carry-in agenda, the top of page 1, it is recommended that the commission adopt the proposed opinion and order granting the petition of Mid-Atlantic Interstate Transmission LLC pending review and consideration on the merits.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Is there any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And the final item on the carry-in agenda, the commission announces its action by notational vote taken on July 25, 2018, necessitated by regulatory deadline, in which the commission adopted the motion of Commissioner David W. Sweet in the case of Pennsylvania State Senator Andrew Dinniman versus Sunoco Pipeline LP at the consolidated docket numbers P-2018-300-1453 and C-2018-300-1451. Commissioner Sweet's motion granted in part and denied in part Sunoco's motion for certification for interlocutory review of the Commission's June 15, 2018 opinion and order. The tally of the Commissioner's notational vote was 3-2 in favor of adoption of the Sweet motion. Individually, the Commissioner's votes were cast as follows: Chairman Brown voting against the Sweet motion in a dissenting statement, Vice Chairman Place voting against the Sweet motion in a dissenting statement, Commissioners Kennard and Coleman voting in favor of the Sweet motion in a joint supporting statement, and Commissioner Sweet voting in favor of his motion in a supporting statement. The opinion and order was adopted by a majority of the Commission, entered by the Secretary of the Commission on July 25, 2018, and served upon the parties. Therefore, it is recommended by the Office of Special Assistance that, consistent with 4 PA Code Section 1.43C, this action be recorded and entered in the minutes of this public meeting.
Is there a motion to adopt the staff recommendation to accurately record our notational vote?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman, that concludes all public meeting items for today's consideration.
If there's nothing else to come before the commission, is there a motion to adjourn? Motion by Commissioner Kennard, second. Second by Commissioner Sweet. I'm assuming everyone's in favor. We are adjourned.